All right, good.
All right, great. Welcome to the Lomurro Law Firm. Jerry Buting's here. He's our guest, everybody. Today we have the Public Defender's Office has come back. They had so much fun with Dean, they wanted to come back and meet you. You actually may even be more relevant for them because you were a public defender for an extended period of time. How long?
About 9 years.
9 years. So they definitely have a connection with you. I also have some students from Seton Hall. That is our, in my opinion, the best university in New Jersey. If you ask my dad, he'll say Rutgers, but minds can differ, I suppose, and some other people. So welcome to the show, Jerry.
Thank you. Thank you. Good to be here.
All right. We talked a little bit before about an article you posted on Twitter, and I had a chance to read it. I wanted to start there because I thought it was a good place to get a discussion going. It talked about what I'll call prosecutorial bad faith, or as the article was titled, the innocence deniers. So in that article, I want to start with a quote, and the quote is from a United States Supreme Court case decided in 1935, Berger versus the United States, which famously declared that prosecution's ultimate goal is not that it shall win a case, but that justice shall be done. And it seems to me that you are on somewhat of a crusade to make sure that that theory comes back and is enforced. And you had firsthand experience in that theory not being enforced with one of your clients who spent 29 years in jail, and prosecutors had exculpatory information, specifically information about a confession from someone else. And they buried that information. They didn't give it to you. It's a subject that's sore to you. And I wanted to start our talk out with your feelings on that issue.
Sure. The article you referred to by Laura Bazelon is excellent. It's in Slate just this week, I think. And it's an excellent discussion of a broader issue and then three big prosecutors who illustrate the problem of that I encountered in my case of state of Wisconsin versus Ralph Armstrong in county, where prosecutors who take a position at trial, get a conviction many years later or sometimes decades later, there's evidence that's uncovered that really points towards a miscarriage of justice, the wrong person being convicted, innocence. Which means the real perpetrator going free. And too many prosecutors take the position that they're right the first time, that somehow that they're willing to do a 180 on their theory of prosecution, try and explain away the new evidence that points towards the defendant's innocence when they use that very evidence at trial to try and get his conviction, and only when it proves now to exclude the defendant do they say, oh, well, that really probably didn't come from the real killer. It was casually deposited for some other reason, unconnected to the murder. But that's not what they told the original jury, of course. And I experienced that in a number of cases. The one I discuss in most detail is the Ralph Armstrong case.
Right. So the Ralph Armstrong case, I have a picture here for our listeners who can't see it. There's a picture of you all the way on one end of the picture. Then there's Barry Scheck, who founded the Innocence Project, in the middle. And then there's Mr. Armstrong on the other end of the picture. Essentially, what happened in that case is someone had called in to the prosecutor's office and said, look, someone confessed to me and said that they committed this murder. This guy's sitting in jail, and they basically turned a deaf ear to that. You didn't find out about it till 10 years later, right?
That's right.
And this is exactly the type of example that you think has got to have consequences. That's basically the theory behind your crusade now, I assume.
Yeah, I mean, that's part of my crusade for justice and justice reform. Actually, in that case, the original prosecutor received a phone call from two women who had evidence, had actually spoken to the third party who confessed. They talked to this was in a different state. They tracked down the prosecutor, whose name was John Norsetter in Dane County. They talked to him. They told him the whole story. They told him the details of what the person had said in his confession. The prosecutor claimed that he made no note in his file, told nobody else about it, and according to the women, told them that, nah, we got the right guy. This was the most heinous crime in Dane County history. And at that time, Barry Scheck and I were already retained on Ralph Armstrong's case.
Through the Innocence Project?
Right. Through the Innocence Project in New York, Barry Scheck's office. And I was, I agreed to be local counsel assisting him. Little did I know I would be on the case for 15 years.
Right.
Before we finally got justice. But 13 years went by before we discovered information about the confession, and that was a fluke, largely because of one of the reasons it's in the book is because it was a tip that I received in the middle of trying Steven Avery's case.
Right.
Somebody had emailed me and said they had information, and later we checked it out and it turned to be proved to be accurate.
Right. So it's somebody in Texas, right, who had come up with the information.
Correct.
And just for our listeners, the murder that occurred in Wisconsin was of a University of Wisconsin student who was raped and killed. A brutal murder.
It was.
But this individual in Texas contacts you because of the Avery case, and seeing the exposure from the Avery case tells you what they had already told the prosecutor, which is the only reason you ever found it out. You would have never known it had it not been for that. And that makes you feel pretty uncomfortable, doesn't it?
It does, and what made me feel even more uncomfortable is that shortly before I got the tip, the prosecutor had done a remarkable thing in violating a court order and allowing. What happened was that while the Avery case was being prepared pre-trial, I was working on this other case as well. We had gotten the conviction reversed by the Wisconsin Supreme Court. They said he's entitled to a new trial. And the prosecution said, well, we want to retest some of this evidence before we decide whether to retry him or just dismiss the case. One of those tests turned up a new semen stain that was found on the murder weapon, which was a bathrobe belt that was used to strangle her, found on top of the victim's body. And DNA tests excluded my client and excluded the victim's boyfriend, fiance. She was not known to have had any other sexual partners, so it was very likely from the killer, who clearly had handled the bathrobe belt by placing it across her back. I thought the case was going to be dismissed when that came out. I had been very cautious about the retesting process and had gotten a court order that said the state could not do any retesting without first notifying me, allowing me to be present and view any movement, repackaging of the evidence and that sort. And they complied with it at first until this test came back exculpatory against my client. Then when they decided they were not going to dismiss the case, they announced in court that they were going to retry him anyway, that they still believed Ralph to be guilty. I said then I wanted the opportunity to retest it ourselves. This was a partial profile we thought we could develop further with some of the world-renowned experts that the Innocence Project has access to. And within
tough luck, right?
Pardon me?
Tough luck, right? Nothing left for you.
Well, there was at that time when we said that in court. And the judge said, "Fine, you can do that. I'm gonna allow that to be done. Get back to me when you know where the evidence is, the status, etc." Within days of that hearing, the prosecutor violated the court order, directed his detective to the clerk's office, removed the bathrobe belt murder weapon, sent it back to the crime lab for additional tests that destroyed the sample before the defense could test it.
That's even worse than not having anything available. They had it available, destroyed it, and you were,
And the test that they used was kind of surprising to me when I first discovered that they had done this, because it was what's known as a YSTR test. It looks only at the Y male chromosome. And because of that, everybody in the paternal line, brothers, fathers, nieces, or nephews, uncles, they all have the exact same YSTR profile. And so it's not as powerfully inculpatory as other kinds of DNA, normal nuclear DNA would be. And so
yeah, that's a problem in this particular case, right?
It was a real problem in this case because, without going into too much detail in it, the individual who had confessed was in fact related to my client. And the YSTR test, if it's proven accurate and they ultimately couldn't get a high enough profile, it would have been indistinguishable from my client.
Right.
It would have, in essence, framed him for a crime that he didn't commit and that only the prosecutor knew the third party had confessed to. That, to me, was shocking. And it was one of factors the court had to consider before they ultimately decided to dismiss the case because of prosecutorial misconduct.
So they dismissed the case. I guess a question for you is, in this type of scenario where it's obvious, the case was dismissed and the judge put on the record how disappointed they were with the prosecutor's tactics in this case. In that type of situation, most of the time there's civil immunities, there's criminal immunities. There's really not much that can happen to the individual who does the misconduct aside from the case being dismissed. Is that fair, or should they have some real consequences?
No, I think it's very unfair. And the reason that typically prosecutors have immunity, it's actually absolute immunity from civil liability, is it's basically court-created law. It's not legislative enactments. And it's based on the premise that, as a matter of public policy, we don't want our prosecutors to be chilled from the exercise of their proper prosecutorial duties by saying, maybe I won't charge this person because I could get sued. And so we grant them immunity when they are acting in their prosecutorial function. Problem, though, is when you go so far as to say that a prosecutor can deliberately violate court orders or deliberately destroy evidence or withhold exculpatory evidence and say that kind of conduct is still absolutely immune from civil liability. I think that goes way too far. And I think that if we didn't have that kind of immunity, at least some of the bad actor prosecutors, and thankfully most prosecutors aren't like this, but even the ones that are, I think they would be deterred from withholding evidence that if they later got caught, they realized that they could be in serious trouble, or destroying evidence, that sort of thing.
Well, isn't it the same as official misconduct for police officers? I know in New Jersey here, they have pretty strict laws for police officers. If they fabricate evidence, if they lie on a police report, they can go to jail. They're not going to just lose their job. They're going to go to jail, and it happens. So I think that, to take the position that there's a chilling effect is a little, I think it's false. I really do. People are there to do their job, and they should be able to do it in a good faith, and we shouldn't have to have immunities, I don't think. So it works for police officers. What's good for them, shouldn't it be good for prosecutors?
It should, and for police, it's qualified immunity. It's not absolute immunity, and so when police are found to have acted outside the law, contrary to clearly established or prevailing law, then they are liable. And certainly in a situation where they're planting evidence or deliberately beating somebody or violating the law, then they're liable. And I think a similar standard could be applied to prosecutors.
What about a gray line? And this is a good transition into the Avery case, because I think a gray line might have been Ken Kratz's press conference, where he may not have been covering up evidence, but he damn sure put on a show that really tainted any possible fair trial that Steven Avery or Brendan Dassey could have had. How close was that to prosecutorial bad faith, or was it?
Well, I think it crossed the line. It was always my opinion to cross the line on ethical limits that we already have and had in place at the time in Wisconsin on what a prosecutor could say publicly about a pending case. This country, when the Making a Murderer came out, I got so many emails and tweets from people all over the world saying, "Oh my God, I can't believe that press conference. That could never happen here." And it's true, most countries it couldn't happen because
there's prohibitions on it.
Prohibitions, and it could, reporters and individuals or police agents who make statements like that could be held in contempt of court, particularly the closer it gets to a trial.
Right.
But we have the First Amendment in America that makes it much more difficult to restrict public comments by the media. When it comes to the acting lawyers in the case, the prosecutors or the defense, then there are ethical rules that limit what you can say and do, and even before or whether or not there is any so-called gag order issued by a judge in a case, like you've seen in the Paul Manafort case that's pending right now, and the Trump campaign Russian investigation. There's a particular gag order that limits those parties from discussing the case publicly. But in Mr. Kratz's case, I think he went way beyond the line of ethical limitations on what a prosecutor could say. Now, what are the remedies for that?
Yeah,
is the real question.
Right.
Ethical remedies don't necessarily help the individual client whose right to a fair trial has been irreparably damaged. Steven Avery's case.
And facing life in
so
prison.
I think the courts have to. Yeah, I think courts have to get stronger. It's not enough to just say, "Oh, well, the prosecutor might have his license suspended potentially." I think there's got to be some real teeth in it, even to the extent of dismissing a prosecution altogether. If a DA does what Ken Kratz did in this case, which is to pollute the entire jury pool with deliberate statements in a press conference organized by himself for that purpose.
That makes me think of the Duke Lacrosse case where the DA actually was suspended, the case was dismissed. Now, in that case, factually, the allegations never occurred, so it was a lot easier to dismiss that. But I think that had some real teeth to it, where there was that type of misconduct. I don't know what the answer is, if it could have been like that in the Avery case, but certainly there should have been some type of repercussion, I believe.
Yeah, and actually in the Duke Lacrosse case, it was not just the public statements. It was also when evidence came out that the prosecutor knew before the public statements that there was exculpatory DNA and withheld that from the defense, and then he continued to make these public statements that were so damaging. So the interesting thing about that is that case was going on just before the Avery case prosecution, and there was some discussion about that, the parallels between the Ken Kratz press conference and the DA knife-on down in Durham, while that was going on. So
it's interesting. It's interesting parallels. So, one reason I knew about the Armstrong case so much was that you wrote about it extensively in your book. The book is called Illusion of Justice. I tore through it. It was a wonderful read. I said to you when we spoke last that I thought it read more like a Grisham novel than it did like a law book. So I really think it's a fun read for anybody who gets their hands on it. But you wrap the Armstrong case around the Avery case. There's some similarities. But one of the other things I liked about the book that you didn't get from the TV series or from any of the podcasts I've listened to, frankly, is an inside and emotional look about how you and Dean basically moved your entire life to 2 apartments and tried this case. I'm assuming you felt like you were almost in seclusion there, and the emotions that kind of followed you around throughout the trial. Tell us a little bit about what was your desire to tell the public about that. Did you think they were missing it?
Well, I do think it didn't come across quite as well in the documentary, although I thought there was at least a good flavor of it. One of the reasons that Dean and I agreed to participate in the documentary was that we thought it would be a good public education opportunity to kind of look behind the curtain and see what it's like to be a defense attorney preparing for a trial and trying a real serious case like this. At the time we agreed, I actually thought the prosecutor was doing it as well. Pat was offered the same opportunity that we were, and in some ways I thought it would have been really interesting to see the juxtaposition of prosecutors' preparation, behind the scenes, interviews or just even discussions between the prosecutors like you saw with Dean and I. But, I think that's, you certainly don't see it in Hollywood, fictional portrayals of what it's like to be a defense attorney, at least we haven't in the past. And so I thought it would be a good chance to do that. And some of that comes through in the documentary pretty well. But I thought I could also give more perspective in my book, and not just about the Steven Avery case. So the book is a bit of a memoir, too, about what it's, kind of the making of a criminal defense attorney.
Yeah, I got that feeling.
And what that involves and what kinds of things motivate us to be criminal defense attorneys, how we deal with the pressures, why we do it, what it's like when you're in the midst of it. It is all-consuming when you're in trial, particularly a big, serious trial like this.
Yeah.
You really are almost in the seclusion and bubble of trying a case. You get up in the morning, you get to go to court, you're in court all day. You break and have maybe an hour for dinner, which Dean and I usually ate together, so we were talking about the case even during dinner.
At the only diner that you were able to find where you could have some anonymity, which I like. See, those are the type of things that you don't necessarily get from the series. I thought that was fun.
Yeah, it was hard to find in Shelton a place to eat where we weren't. Obviously, we were very recognized anywhere we went.
But not in a good way like you are now. But that was when everybody was looking at you like a monster, because you were with the bad guy. So it was different then, right?
It was very different. It was 180 degrees different.
Yeah, which all the public defenders, they know. I mean, people, how can you stand next to that guy, right? And now you're trying to eat eggs at IHOP, and everybody's looking at you sideways. So, which is a challenging thing. But I did think it was interesting to get that aspect from you.
Yeah, and so I tried to convey some of that, and the difference. It's true. There was one little mom and pop diner where we could go every day for lunch, and they were very, very nice, non-judgmental, had great soups, grilled cheese, which was Dean's regular staple. So, but it is, you're living in a bubble. Every waking moment you're either in court or preparing for the next day's court. And that's just kind of the way it is, and it's adrenaline keeps you going.
Yeah. But I don't want to take away all the good stuff from the book. I want people to read it and get it. But one part that you just talked about, hard to turn it on and turn it off. It seemed from the series that you developed a real fierce rivalry with Kratz, and in the book you described one time where you were in chambers. It was you, Dean, the judge, and Kratz, and you guys really got into it to the point where you thought you might come to blows. It's interesting because, it's not fake. It's real. We live in, as trial lawyers, we live in an adversarial world, but, that can follow you, into your inner life, and you can internalize those feelings. What was that like? Was it really that bad between you guys?
Yeah, it certainly got that bad by the end of the trial. From the beginning, Ken Kratz and I just never got along. We were just kind of like oil and water.
I can't imagine why.
Well, it's not like that. It has not been like that with me and other prosecutors. I generally get along with other prosecutors. They respect me. I respect them. I understand their role. And if I disagree, we disagree civilly. But the whole way that press conference was run, and then the way that Kratz from that point forward led the prosecution, it just never sat right with me. Dean was much more of the sort of the mediator in between. Unintentionally, Dean and I sort of developed this good cop, bad cop kind of roles.
Right, you're the bad cop. We talked about that.
Bad cop, and it fit with my relationship with Ken Kratz. We've never gotten along before or since. By the end of the trial, I describe it in more detail in the book, so we don't need to do that right now. But there was tensions were high. We were waiting on a jury verdict. I'm sure I knew even at the time, but looking back even more so when you see some of the footage of the prosecutors and the defense kind of walking around waiting on the verdict. It's a high drama, intense period of time as you're wondering. What's the jury talking about? What are they thinking? Which way is it going? And And I'm sure that in this case, the more time that went on, the prosecutor was getting more and more tense, to the point where he was afraid maybe he was going to lose. And when this issue came up in chambers, he kind of lost it, or almost lost it. And Dean played the peacemaker yet again.
So I want to talk to you about Brendan Dassey a little bit. Another part of the book that I didn't know was that when you first met Steven Avery, or when you first met with Dean to discuss representing Steven Avery, at that same exact moment, Brendan Dassey was arrested, and the thought ran through your mind whether you should be representing Dassey. And it probably, if there was ever an opportunity for that to occur, it was that moment. You ultimately decided you could not do that. What was that like?
That was very strange. That was really a freak of timing. If I had set our appointment an hour later, I might have been available to represent Brendan. But the way it happened was Dean had just been retained a week or 10 days before that. I had been contacted to see if I wanted to join with him, but we needed to talk about some of the parameters of what that would be like. We'd worked together on a case. We'd never worked together on a case that went to trial before, and never representing the same individual defendant. It was instead more often co-defendants. So we set up this meeting. I go over to Madison. I'm meeting in Dean's office, and we're talking for about an hour, and he's kind of debriefing what's happened so far, what he knew, when the phone rang, and it was somebody from the family saying that Brendan had confessed, been arrested, implicated Steven Avery, and obviously this young man we didn't really know who he was at that point. And this young man was in a lot of trouble, very serious trouble, and needed a good lawyer. But by that time, we had already shared enough sort of private information about Dean's knowledge, having represented Steven for the last week or so, that there would have been a conflict of interest for me to switch and then represent Brendan, who was a co-defendant.
Right, but it came that close. Very interesting.
Yeah.
You say in the book, Brendan Dassey was never physically in the courtroom during his uncle's trial, but his story loomed over the proceedings, a weather system that never cleared. Your back was against the wall because there was a statement, and he has a Fifth Amendment right to remain silent and not incriminate himself, so you couldn't call him as a witness. So essentially, that you have this damning statement that's out there that's been publicized to all the people who undoubtedly the jury had heard it, yet you couldn't address it at the trial. How bad was that for Steven Avery?
That was a challenge, and frankly, I thought that was, from a pure legal strategy, trial strategy viewpoint, the smartest thing that they did. The prosecutors, and not calling.
Right. And maybe saving the second trial, not trying him along with Steven, right?
Yeah, right, not using him in Steven's case. The only way his confession could have come in was if they called him, right, and gave him immunity. If they had called him, if the prosecutor had called him as a witness, he could have simply shut it down and taken the Fifth Amendment. But if they had given him some kind of immunity in return for his testimony, which is what we were expecting all along they would do, then his confession would have been, all of his various statements would have been fair game for us. All of the techniques that the prosecutors or the investigators used against him would have been fair game. We think it would have played into our defense very well by showing just how desperate these prosecutors or these investigators and prosecutors were willing to go to get Steven Avery. Mm-hmm. To use these coercive techniques against his 16-year-old nephew. So instead, we had to kind of shadow box, disprove the actual content of his publicized confession, the one that was part of the press conference and that people were aware of, without ever using or addressing it directly. And so all we could really do is point out how there was no physical evidence of any kind of rape or murder in that bedroom, no DNA or blood of any kind of Teresa Halbach anywhere in the Steven Avery trailer, and so on and so forth, to try and show the jurors we knew had heard some of the details of that confession before trial, try and show them that the facts just didn't fit.
Actually, we talked about that with Dean when he was on the show, about the impossibility to clean up that amount of carnage, blood, whatever else. There was no damage on the furniture. If the murder had occurred the way that Brendan Dassey described it, there would have had to have been some evidence. And in fact, in the book, you say that the investigators came in, jackhammered some of the garage, pulled it up, and tested it. They find Avery's DNA on the floor, but they don't find Teresa Halbach's, which is impossible if you bleach. If you bleach, it's either there's no DNA or there's both DNAs, but you can't. There's no magic bleach that only gets rid of one person's DNA, not someone else's. So I thought that was pretty crazy. I mean, how do you feel about that?
Yeah, there's no question, and we tried to present that during the trial as well. That not only would bleach have wiped out all DNA, including his, how would he have known where her DNA and blood was, but not his, and be able to sort of almost with microscopic vision, be able to, Superman vision, be able to figure out, aha, here's her DNA. I'm going to clean that up with bleach and miss this part over here because this is just my DNA. It's nonsensical. And they never offered any explanation that I recall during the trial about how that could have happened.
Yeah, that's pretty wild. You were poking holes in a lot of the evidence. That was obviously that's always defense counsel's role is to try and counter the prosecutor's evidence. Specifically, the magic key. You described it as a good day for the defense when you took down a witness called Chikarsky. Am I saying that right? Kucharski. Who was there in Steven's bedroom initially and never saw a key. He then comes back with two of the officers who are not supposed to be there, who were precluded from being part of the investigation, who are then with him, and he admits that the key all of a sudden pops up when they were there, and he actually gives it up to you that certainly it was possible that it was not there before and it was there now. How was that examination? How did you prep for it? Were you surprised you got it out of him?
Well, that's the witness who says, well, yeah, it's possible that they could have planned it without me seeing it. Just as possible as if aliens came down and planted the key. Right. So I wasn't. I knew he was going to be generally a good witness for us because it was the only day that a low-ranking officer had from Calumet, who was supposed to be controlling the investigation. It was the only day that a low-ranking officer was there in the room with the two Manitowoc detectives. And before that, there had been a sergeant from Calumet, and I don't know that I knew until the trial when I was questioning the sergeant that he had actually been advised that his role was to be a watchdog, to make sure that they didn't pull any funny business, which is really, to me, even now, preposterous. Well, what do you have those people in the room for? Why are they even there? If you're using your manpower to watch them, why not just have your own people search it or the state DCI people search it and keep these conflicted, biased investigators away from the scene altogether? But when Kucharski was there, for whatever reason, the sergeant wasn't available that day, Sergeant Tyson. So Kucharski is a deputy, and he's not even told that his role is to keep an eye on these Manitowoc detectives. Then he's just there to gather any evidence, and that's not unusual. There's one person maybe assigned to bag the evidence, initial it, staple the bags closed, and that sort of thing. So he's distracted by his other duties and not told that he's to be the watchdog. So I knew that one occasion when they found the magic key that suddenly appeared in plain view and hadn't been there before, that it was under circumstances where they could very well have planted it without the one non-conflicted officer in the room not noticing.
Right, and it was pointed out well in the series. The magic key was a big part of that, but there was, a lot of other evidence. And if it was just a magic key, maybe it's over then. Maybe there's enough. But there was a lot of evidence similar to the magic key that you had to poke holes in. Maybe it was too much to digest. So just a couple that I look at, and you went over these in detail in your book, but you have the key in the bedroom, the magic key. Then you have the bones outside the bedroom, and that's a very, very difficult fact to digest. Even though we know from our discussion with Dean that probably those, or at least your expert believes those bones could not have been burned there because the source of heat could not have been hot enough for the cremation to be the way it was.
Right.
So then you have the bones outside the bedroom, the blood in the RAV4, the contaminated bullet, and the keys in the bedroom. If you want to believe, or if you truly believe that Avery's innocent, you have to believe that the police planted all of that evidence, or someone did, right?
Or somebody did.
Somebody
right.
did.
That was the issue. It wasn't. There was a number of things about the bones, and by the way, the after the documentary came out, Ken Kratz was going around with a laundry list of all this supposedly powerful prosecutor favorable evidence
like
that
the
was
sweat DNA,
right.
which is
Yeah,
false,
yeah.
completely false. There's no such thing actually for the listeners.
Right.
There's no such thing.
Right, but the filmmakers had to make judgments calls. They had to decide what to leave in and what to leave out. I mean, this was a 6-week trial. Nobody would sit through that, a full 6 weeks. As it was, they spent 3.5 hours with actual courtroom footage from either the Steven Avery or Brendan Dassey trial. So that was a lot of coverage, but they had to make decisions. And I don't fault them for the decisions they made, but they also left out some of the defense evidence in the case. And the bones, I think, was one example of that. To us, the bones evidence was the most powerful for the defense because only 40% of her bones were ever recovered.
Right. In three different locations.
And they were in 3 different locations, and they were not all at the burn pit. And so there was clear evidence that the bones had been moved, and the question was, were they moved to Steven Avery's pit or away from his pit? If they were moved to his pit, then Steven Avery was clearly innocent because nobody would burn a body somewhere else and then dump it in your backyard. And so we thought that was very important evidence, especially the state, I believe, argued that the state's expert argued, well, because the majority of the bones were found in Steven Avery's burn pit, and some of them were very small bones, that they're like, inner ear bones or something like that, that means they must have been burned there. But our expert, who was really a world-renowned expert, Dr. Scott Fairgrieve, disagreed and said, look, he has found more bones out in the wilderness, frankly, than she has, maybe than anybody. And he has seen cases where the secondary location is the location that has the primary, the majority of the bones, which is also common sense. If you're going to burn a body someplace and then try and remove it, get the evidence off of your property, you're going to move most of it to the secondary location or wherever you want to put that. So that was powerful evidence for the defense. It didn't come across that strong in the documentary, I think, but it was, we thought, very useful for us. And the other evidence, we talked about the key, the blood, we thought we had an explanation for, at least one possible explanation for.
Right, that was the big find in the series, was that when you were able to capture that moment when you say, game on, we got something here. That you didn't love that. You didn't love that part because it was so raw, but the audience was really able to get a feeling of how amazing it is that moment when you find a needle in a haystack, and you did. You did find a needle in a haystack when you found a puncture hole in a vial of blood that was from the original case that Avery was exonerated from. So very old blood, a puncture mark, which indicates that someone had tampered with the blood. A huge find. And tell us a little bit about that moment.
Yeah, well, in the documentary, it looked like it was just the puncture hole that was, the most important factor. But that's because that's what I focused on when I first looked at it. But as we looked more carefully, it wasn't just the fact that there was a hole in the vial, the rubber stopper, because you've got to get the blood in there some way. When you're first taking it out of someone's arm, there is in fact a needle that goes through that. But those are self-sealing stoppers, and the phlebotomists I talked to, when they pull that out, there isn't a visible hole left. It seals for obvious reasons, so that blood doesn't leak and come out of there. But was really the most important thing was that it was in an unsecured location. There was evidence that the Manitowoc County Sheriff's Department knew it was there. It could have easily been accessed, therefore, without anybody noticing it. There was blood up in between the stopper and the glass that showed either the stopper had been pulled off or someone had stuck a hypodermic in there. There was a vacuum effect as they're sucking blood out. What was the most important aspect of it was that it was available to the Manitowoc County Sheriff's Department, bad actors if they wished to access it, and there was no way to prove that they hadn't, because it was unsealed. There was no tape around the stopper. It was not in a clerk's vault. There were no surveillance cameras that would prevent them from having access to it, and they had pass keys that would allow them to go in to the clerk's office at any time of day or night or weekend.
They had the access. So Avery sits now in jail for life. He sits in a different position than Dassey, because Dassey still has what I'll call a prayer to go to the United States Supreme Court to review whether his statement was coerced. But even if his statement is coerced, that doesn't help Avery out. The only thing that helps Avery out necessarily is new evidence that could exonerate him. So maybe a science comes along that proves that there was an anticoagulating element to the blood. Is that something that would be good enough? Do you have to find that type of new science to fit to the evidence?
Yeah, it could be. His new attorney on post-conviction, Kathleen Zellner, has introduced, filed motions and affidavits describing a lot of newly discovered evidence. Unfortunately, the judge never even allowed a hearing on the newly discovered evidence, or even required the state to file a response. The state never really addressed, what their arguments against the newly discovered evidence that she's presented would be. And so, unfortunately, now his case is back up in the State Court of Appeals, and the issue, I think, will be, should it be sent back for a hearing, or was the judge somehow entitled to deny a hearing on the basis of the motions that were filed? I think that's a stretch. I think at minimum, a hearing should have been held. Witnesses should have come in and had presented their testimony, give the state a chance to cross-examine her experts. It's possible Dean and I could be witnesses at that kind of a hearing, give the prosecution and Kathleen Zellner an opportunity to question us under oath. That's typically what you would have in a case where there's something more than just conclusory allegations about there being newly discovered evidence. Here she had experts presenting affidavits. The testing wasn't complete. That's another issue, is that some additional tests still need to be done and should be done. I'm frankly surprised that the state has been more forthcoming in saying, look, let's just test it.
Right.
Go ahead.
Right. Let's do the right thing. Let's figure it out.
If we're so convinced that Steven Avery is guilty, have at it. Test whatever you want, because we're confident it's not going to exonerate him. But the fact that they're so resistant to that should give people pause as well.
Here's a question for you. The only thing that was shared in common between Avery and Dassey's trial, the murder theory, was the victim. In the first trial, you have a theory by the prosecutor's office that it's a single person committing the murder, which is Steven Avery. In the second trial, it's a co-conspirator theory between Dassey and Avery. Doesn't that, in and of itself, run afoul of what we talked about before, doing justice. If they have a different theory of the murder, you got to pick one. Pick the one you believe is true. Try that case and believe in that case. And you can't split the theory. It doesn't make sense to me.
It doesn't make sense, and that should be the law, that they should not be allowed to do that, because, you know, if the trial is supposed to be a search for the truth, and in a case where the prosecutor gets up and argues one individual and only one individual is responsible for this crime and gives an explanation for supposedly how it happened, and then in a different trial with another co-defendant completely changes their whole theory of prosecution and argues the crime even occurred differently in a different location, that's just inconsistent. One of those versions can't be true.
Right.
It's really an effort by the prosecution to get a conviction, not to seek the truth. Unfortunately, American courts too often allow that. There are a few cases that have rejected it and have found that it's a violation of a defendant's due process to do that, but they're few and far between.
I wonder if there's a way to. I mean, that seems to me to be an issue that's ripe for consideration. But who knows? All right. Well, the last part of the show. Well, actually, before I do this, I want to talk about on your personal opinion. You stated unequivocally in your book that you do believe Avery is innocent. What is your number one reason for making that statement? That's a bold statement. It's not that he's not guilty; it's that he's innocent. What's your number one reason for that?
The nature and quality of the evidence against him was so suspicious. You know, I've been doing this a long time. I've never seen a collection of highly suspicious circumstances under which evidence is found, like happened here, and found by people who have a clear motive, an animus, as we would say, against this defendant. That should never have been involved. Manitowoc found, their investigators found almost all of the evidence that was used against Steven Avery. And under circumstances like the magic key or the bullet that was discovered only 5 months later, with some of the same Manitowoc actors present at the time, you know, none of that that looks so highly suspicious. And then when I add to that the lack of motive on Steven Avery's part, you know, he was about to come into a $400,000 cash payment, tax-free, that was awarded by the legislature as like a special bill. Wisconsin law is so antiquated that a wrongly convicted individual is entitled to compensation from a fund, but only $5,000 per year of incarceration for a maximum of 5 years. $25,000. Who would spend a night in jail for that, frankly, much less 18 years like Steven Avery did? The only way around that then is for the legislature to pass a specific appropriation type bill, and they had already done that, and it was sitting on the governor's desk to be signed. And so why would he have done this under these circumstances? That's separate from his $36 million lawsuit that he had pending against the Manitowoc County people. So the lack of a motive, the highly suspicious circumstances under which the evidence against Steven Avery was found, and it's so obvious that it had to have been deliberate failure to investigate other possible suspects. You know, I've said this before, and it's common knowledge that when a female is found murdered, in 95% of the time, the perpetrator comes from those who are very close to her. You know, husbands, ex-husbands, boyfriends, ex-boyfriends, roommates, colleagues at work, whatever. That circle of friends were never thoroughly investigated by the police in this case. And, you know, we named certain people in a motion, what's called the Denny motion, which is to allow us to present evidence of a possible third-party suspect at the trial. There were others that we couldn't name because we weren't able to even develop enough evidence, since they all kind of circled the wagons and refused to talk to the defense. And that's actually common in a criminal investigation, where those family and friends who are close to a victim are not going to be cooperative with somebody who's then been charged with their murder. You're representing who? I'm sorry, the door gets slammed in your face. But the police have that authority early on in their investigation to do that, to get people to explain, where were you on the night of this murder, and what kind of relationship did you have with the deceased, and and that applies to people who had access to her at the Avery salvage yard.
Right.
Some of whom have now been named as suspects by Kathleen Zellner, and some of those were named by us as possible suspects, but we were never allowed to point the finger at them at the jury trial, so that the jury was really, I think, presented with a lot of important evidence from the defense side. So for all those reasons, the state's theory never added up. Where the crime supposedly happened, the physical evidence disproved their theories. None of it made sense to me. And so, I'm not omniscient. I wasn't there. I can't be 100% certain in Steven Avery's guilt, but from my own gut instinct and my experience as a defense attorney, I think the evidence does not add up to his guilt. He should have been acquitted.
Right. Well put. And if we had more time, maybe I'll get you back on the show. But of course, a main part of the trial was the judge's decision to require you to prove a motive when you wanted to introduce the possibility of someone else having been involved. You were precluded from that. Certainly, we could spend a lot of time discussing that, but that was a big decision, and I'm glad you brought that up. But because we only have enough time for the end of the show, which is called Taking the Stand, I want to go to that part of the segment or of the show where I ask you 5 questions. I ask the same 5 questions to every guest. Are you ready, Jerry?
Sure.
Okay.
I'm on the hot seat.
You're on the hot seat. I have a feeling I know the answer to number 1, but in your career, what single case are you most proud of and why?
Probably the Ralph Armstrong case, because I worked on it so long and for so many years and so hard and against very difficult odds. I'm proud of what we did in the Steven Avery case. I'm not proud of the outcome. I am proud of the outcome in the Ralph Armstrong case, and so I'd have to say that's probably the one case I'd pick. There's a number of them, but I'd stick with that one.
That's the one. It's a remarkable story. You can find out more about it in Jerry's book. The second question is, if you could handle a case with one person, dead or alive, who would it be? It can't be Dean Strang. You already had a case with him.
Yeah, well, Dean would be the first. But since I can't go with Dean and it's dead or alive, I would go back quite a ways to, possibly John Adams, but I think I will say Honest Abe Lincoln.
Yeah. He'd probably be mine too, Jerry.
How many lawyers get the name Honest in front of them? Let's face it.
Yeah. Better call Saul.
Right.
So either Abe Lincoln or John Adams. I think you quote John Adams on the back of on the back of your book. Most people run to him when they want to describe how you can defend someone because of how he represented the people during the Boston Massacre of the British soldiers. It's a good analogy. He's certainly one of the people we look up to in the history of justice in America. But Honest Abe is probably number 1 for me too, Jerry.
All right.
Okay, so one book and one movie that inspired you. Not necessarily in the law, but if it's in the law, that's great. One book, one movie.
The book I would say is Man's Search for Meaning, Viktor Frankl's book. I mentioned it in my book. It was very popular at the time. I don't know if it's quite as popular now, but he was a psychiatrist who was arrested and I believe in 4 different concentration camps during World War II. Lost his parents, his brother, his wife, pregnant wife, I think. Suffered terrible deprivations, and yet kept the spirit. And then later, when he survived and he went into a private practice as a psychiatrist, he did a study on that and concluded that based on his experience and the people that he encountered in the concentration camps, that what really kept him going was this no matter what deprivations he suffered, we can't ever avoid all suffering in our life, but we can provide some meaning to it. And if we search for meaning in life and keep our spirit, that's what keeps us going. I think it's very relevant in this day and age, and it's extremely relevant for a lot of my clients who are incarcerated, and so I've given that book to a number of them.
So like George Michael says, you got to have faith.
You got to have, right. Movie, there's a lot, but I would say 12 Angry Men with Henry Fonda. And an incredible cast of character actors, Jack Ward.
Lee J. Cobb, right?
Yep, Lee J. Cobb. Story of a jury that, 12 men deciding whether or not the defendant is guilty or not guilty. And there's one holdout for innocence. And then there's this whole discussion in the jury room about how he then sways the rest. And it's very relevant today because you hear some of the other jurors saying things like, I got tickets to the Yankees game. Let's get out of here. The guy's guilty. We're wasting our time. And that happens in real life. And I had one sort of 12 Angry Men experience in my career where it didn't end up being an acquittal, but it was a holdout, and there was 11 jurors against this one guy, and he held out forever. And it was because I talk a little bit about it in the book, this radio frequency interference problem that came up with breathalyzers. And this was a drunk driving case. It wasn't a big, serious case, but we were able to prove that these machines that police officers used in their drunk driving investigations, breathalyzers, were so poorly shielded from electromagnetic interference from walkie-talkies and all the cell phones and whatnot equipment, and that they were unreliable. The needles could go way up, and the results could be false. And we found this German scientist who was captured by the Americans after the war and had an illustrious career, became world famous in shielding against electromagnetic interference, even at the jet propulsion laboratories with these huge, massive magnets. So we had him actually come into to the trial testify, and he was this brilliant expert, way above everybody's heads and IQ in the courtroom, including the jurors, except for one.
Except for that one juror.
That one juror was an electrician. Mm. And as Dr. Heinz Schlicka would get down and do all these equations on the paper, and he understood it, and he understood that his opinion was right and held out against all. So that's, but anyway, that would be the movie.
Did you hang that jury? I guess you did, huh?
Yeah, yes.
Yeah. I wonder if some of those things that you see in 12 Angry Men, and like you said, maybe somebody's got Packer tickets, if that's the reason for an inconsistent verdict like you had in Avery's, right?
Yeah.
Because it doesn't make sense otherwise. It does not make sense to have a guilty verdict for murder and a not guilty verdict for desecration of human remains or whatever it's called in Wisconsin, but it doesn't make sense.
It didn't make sense then. It still doesn't make sense to me now, other than as a compromise.
Right.
Where some of those who weren't willing to convict said, well, look, we'll give we'll agree to not guilty on that count if you agree to the guilty on the murder. Unfortunately, it made no difference in the long run because conviction of the homicide was mandatory life.
The last two questions are fill in the blanks. A trial lawyer should never do this.
I would say a trial lawyer should never waive an opening statement. I came up in a time of practice where that was sort of an open question. Some thought, well, we'll waive our opening statement and wait until it comes to the defense case, then present the opening statement.
F. Lee Bailey, who was our first guest, said that you should do that. So I think that you're right that the temperature on that has definitely changed. I would never reserve.
Yeah, I would never reserve it. I think the psychological effect of primacy is too powerful.
Sure. Mm-hmm.
It's too powerful, and I think that you need to let the jurors know at the very beginning of the case, before the state presents their whole case, that look, there's another side to this. This is what you should look out for. Challenge the prosecution's theory. In some countries they don't even have that opportunity. The entire Canada, I believe, the entire Crown's case gets presented before the defense is allowed to get up and make an opening statement.
Not good for the Twitter generation. Not good.
No, definitely not.
Yeah.
That's not.
So if you think about it, back in the Adams days when they had 4-hour speeches and people would go 100,000 people to go watch the speeches, I guess maybe then you can reserve because they had the attention span. That's not going to happen now. Either you're up front, primacy and recency, or you're not getting your hit, I don't think.
I agree. I mean, that's my view. So I have never waived, even when it's just a court trial, which I don't do very often, instead of a jury, where the judge is the fact finder.
Right.
Still, I don't think it's a good idea to waive the opening.
The last question, a trial lawyer should do this every day.
Well, I'm a man of faith. I'm a Catholic, practicing Catholic, and to me, that's a big part of my life, so I would have to say pray. Not everybody is, I understand that, but from my own personal perspective, I would say, pray for at least, the strength to be able to do a good job, to be able to convey your thoughts, have a clear mind, every day through the trial, because there's so many distractions. I mean, that's one of the things that I love about trying cases is there's just so many moving parts. It's such an intellectual challenge, an emotional challenge to be able to juggle all of these things together, to not miss an important piece of testimony because you're thinking ahead about what you're going to ask later, watching how the jurors are interacting with each other. It's a very complex drama, and I think it's well worth praying every day to hope that you can do your best.
Yeah, certainly praying, meditating, whatever it is, smelling the roses. I think that it's an important part of the day. I got to figure out a way to get past the copyright so I can play the George Michael song in our outro. But that's the end of our interview. Thank you so much, Jerry Buting. Let me show you everybody before you leave.
Okay.
There you go. Thanks, Jerry.
Thank you.
All right.